Good afternoon.
Good afternoon.
Good afternoon, sziasztok. Sziasztok.
Dzień dobry,
Uh,
Dr. Horniak and Dr. Chirski. I think now we are waiting for our colleagues from Poland. However, I hope that you are ready to start. If so, I think that in 1 minute we can start it, and I'm going to grab the opportunity to be the first presenter, in a certain sense, to give a more comprehensive picture about the end of our research. I prepare for this moment. Please.
have you have you already been contacted by the travel agency or not yet?
Not. My suggestion is that to continue this part of our conversation not during this event, taking into account that this is video recorded.
Okay.
But of course, after that, we can make an informal meeting about this topic, and I'm also open
Okay.
to do that.
Thank you.
Okay, thank you so much. And now, Dr. Shala, good afternoon for you. And now I would like to start this opening seminar. In this sense, that is the last one, the sixth one, connected to the Polish-Hungarian Research Platform organized by the Institute of Justice in Warsaw. And of course, I would like to transfer my greeting to Professor Adamus, their professor, their colleagues. Be welcomed as to the sixth event of the opening seminar. If I may, I would like to present a broader picture about our research, to present the beginnings and to present a summary as to the results and outcomes of our joint research team. And after that, I would like to provide an opportunity for you to deliver your, in this sense, last presentation as to the open seminars. Ladies and gentlemen, I start my presentation. At the beginning of my presentation, I would like to emphasize that especially the second part of my presentation, it is made from the contribution of my colleagues of the research group partners. I'm going to refer to the outcomes of Professor Adamus, Professor Strala, of course, to my colleagues from Hungary, Zsófia Horniak and Martin Csirszky as well. Therefore, of course, that part of the presentation, they are not the outcomes of my research. However, as to this research, I would like to draw your attention what was the beginning of these topics. We received a kind of menu from the organizer of the present research. And in this menu, they determined some challenging topics connected to the legal protection of farmers. It's worth noticing that these topics, they represent a quite complex approach to the farmers, to the agriculture, and it was a challenging part of our job, how to systematize these topics and how to select, for example, the topics of a monograph. I made this systematization, and at the end of this story, we could determine some approaches. For example, as the agriculture code is an extremely interesting it in a positive sense, and of course connected to the academic perspective. Agriculture code represents a kind of theoretical challenge, how to systematize the legislation itself, the practice itself, of course, the jurisprudence concerning agricultural law. There was also another group, another pillar of this menu connected to the land market issue and to the unfair market practices and the illegal practices connected to food supply chain. We and I considered this group of topics as hardcore topics of the agricultural law and the essence of agriculture affairs. Therefore, we consider these topics as a separated topic for a monograph. There were, however, other, maybe we can say that, new waves of topics typically connected to a more comprehensive approach, connected to sustainable development and the three pillars of the sustainable development. Who knows? Maybe next time we can enjoy an opportunity to write a monograph connected to these also important and essential topics. But as to our selection, we connected to the hardcore topics as to the monograph. In this sense, the concept of the monograph, the title of this concept could be the main pillars of the legal protection of farmers' holding structure on one hand, and on the other hand, the commercial issues. And as to the concept of the book, after an introduction, the so-called part 2 of the book, it is about the agriculture holdings and lands, acquisition issues of the main basis of production. In this part, we focused also on international and EU law frameworks and the potential ways of development. This part, however, it was written by me. And we also concentrated on national level as to Hungary by Zsófia Hornyák, as to Poland via the activity of Dr. Strala. And another separated part of this monograph connected to the protection of farmers in civil and commercial relationship by Professor Adamus as to the Poland chapter or subchapter, and Hungary connected to Dr. Csirszky. I considered this monograph as an essential part of our outcomes, and we were so successful. We could fulfill the conditions connected to deadlines, and we have already launched the publication procedure of this monograph. As to the other activities, and now here there is a kind of matrix of the previously not mentioned menu of topics, and on the other side you can see the authors, the members of the Polish-Hungarian Research Platform. There is a matrix from which you can see that colleagues also focused as to the scientific articles, the second opus. They focused on other aspects of agriculture law. And now, after this, I would like to present some part of the achievement of the members of the group. First of all, I would like to start with achievement of Professor Adamus. first of all, I have to emphasize that here and now you can enjoy only some part of his achievement. Of course, he elaborated in detail numerous aspects of his proposal. First of all, I would like to draw your attention that Professor Adamus presented proposals in the field of civil law, and another group of his proposals focused on legislative proposals concerning the broadly understood insolvency law. As to the first group of proposals, there are some examples of his achievements. For example, a proposal about the comprehensive reconstruction of the entire cultivation contract regulated in the, of course, Polish Civil Code, or, for example, comprehensive proposal to create a new collateral effective against third parties in the form of the agricultural deposit, proposal to create incentives for the establishment of agricultural exchanges, or propose amendment to the Act on Registered Pledges, or proposal to introduce new types of named acts of unfair competition to protect individual farmers. There are some of his proposals. As to the second topic connected to the insolvency law, there are many De Lega Ferenda proposals. Some of them, for example, simplifying the application for bankruptcy and opening of a restructuring submitted by an individual farmer, to make it easier for individual farmers to conclude an arrangement by introducing automatism, to introduce a right for an individual farmer consisting in a unilateral temporary suspension of the obligation to perform the arrangement, and so on and so on. For me, that was an extremely interesting part of his proposals. Introduction of a mechanism consisting in the purchase by the state treasury of indebted farms under bankruptcy proceedings in order to later lease them to farmers with preemptive rights. If I may, I think that these proposals are extremely valuable and precious. As to my colleague from Hungary, Dr. Martin Csirsky, one group of his proposals connected to the book chapter, to the chapter of monograph, and the second group connected to the article. He also assessed in an absolutely good way, from an absolutely precious point of view, the analyzed topics. Besides, or in addition to this, he also made some proposals, the Lega Ferenda proposals. For example, that the current protection system could be expanded with the reform of the other two pillars of competition law, that is abuse of dominance and merger control. Or in agri-food markets at the processing, wholesale and retail level, a presumption should be introduced, according to Dr. Csirsky, that an undertaking with 25% of the market shares in the relevant market is in a dominant position ex lege. Or what goes beyond the area of law as a possible development direction is the encouragement of procedures to combine forces and sell their produce together as members of producer organization. In addition to this first group, he also dealt with the topic connected to the following proposals of the EU competition law. Market players in the agriculture sector must be cautious to treat their sustainability-related agreements as automatically exempted from EU competition law pursuant to Article 210A. As to this article, with the exemption of its personal scope, fits into the regime of the agricultural sanction system of regulation and the given number. If a competition authority would have liked to assess the sustainability agreement within the framework of the individual exemption, it could do so even in the lack of Article 210A and so on and so on. As you can see, Dr. Chirsky's regulation connected especially to the competition rules and the competition law approach. It's not a coincidence taking into account the experience of Dr. Chirsky. As to Zsófia Hornyák, Dr. Hornyák also dealt with two topics. One of them connected to the agriculture holding regulation and quite close topic, the regulation of agriculture succession. This is one group of her proposals, and another one connected to the transfer of agriculture holdings. As to the first topic, and her proposal is unification of concept of holding would be welcome in both Hungarian and Polish regulation, taking into account that there are numerous types of these concepts. It would be worthwhile to develop one concept of agricultural land and one of agriculture holding. And then it would be possible to move in the direction of the establishment of a unified holding regulation, according to Dr. Hornyák. A full holding regime for holding transfer should be developed first, including the issues of succession of holding, and to fit the rules on the transfer and succession of one of the elements of the holding, which is the land, into this system. And as for the regulation of agriculture succession, in both countries, at present, there are no coherent sui generis regulation of agricultural land holding. Therefore, the general proposal is, in the case of regulation of succession of agriculture holding and as part of it of agricultural land, a complex system should be established where the rules of testamentary disposition and interstate succession are formulated along the same principles. The sui generis succession rules for both the holding and the land should be laid down in such a way as to avoid fragmentation of the holding land in the succession and to take into account the succession of a person with competent special skills and experience in agriculture production that will enable proper management. According to Zsófia Hornyák research as to the transfer of agriculture holding, there is a proposal that new special legal institution in Hungary, which facilitates generational change, a good tool to help the young generation to acquire ownership of agriculture holding and a step toward classical holding regulation, but the regulation needs to be clarified in Hungary. Of course, there are other details as to her proposal, but now as a summary, I emphasize only these elements. As to the achievements of Dr. Strala, you can see the similar separation of the topics. As the first one, he focused on definitions of agricultural real estate and agriculture holding in the law of April 11, 2003. And these definitions should be made coherent with the corresponding definition in Polish Civil Code. In addition to this, he also emphasized that rules for acquiring agricultural land on the grounds of an acquisitive prescription should apply to agricultural land of an area not less than 1 hectare. And as to the first group, They also emphasized that ordinary bequest needs to be treated equally to specific bequests. Thus, exemption from the rule that only an individual farmer can acquire agricultural land should also apply to the transfer of an agricultural land done in the execution of ordinary bequest. As to the second group of his achievements, here you can see that it's connected to the rules of the slaughter of animals, and according to his achievement, the text of the given provisions of the Act in 1997, which deals with the rules of slaughter animals, they does not reflect the true state of the law, and thus it needs to be changed. The amendment should precisely regulate the issue and did not expose the farmers to the risk of committing a crime due to the uncertainty of the provisions of law and its interpretation. And there are other valuable parts of Dr. Strala proposals, detailed partly on the slide, partly, of course, or in a more detailed form in his article. Last, maybe I can say it, but not least, of course, I would like to present my achievement as well. It's worth noticing that as to my first topics, the topics of the monograph, I focused on EU and international aspect. Therefore, in this sense, to make de lege ferenda proposals, it's a little bit another dimension, because the achievement of this procedure is not merely depend on the given state, but of course the given situation, whether the other parties of a negotiation are open for these ideas or not. However, as to the international investment agreements governing agricultural land acquisition, in settling the pending extra EU relations, Polish and Hungarian decision makers will apply their concept developed within the scope of the new international investment agreements that are already in force, which have been translated into reservation on tenure. That is a kind of beware of the situation that the states, Poland and Hungary, in my opinion, and taking into account the concept of agriculture legislation, they should continue the practice previously pursued by them. As to the relevant EU framework and taking into account the detailed rules of Poland and Hungary concerning acquisition of agricultural lands, and taking into account that nowadays there are numerous reform ideas in connection with the primary EU law, I was quite brave to determine the following ideas. That is the most as an idea, if there are maybe a topic to change the treaties of the European Union, that the most important thing would be to allow member states, in my opinion, wishing to operate a regulated market for the acquisition of their agricultural land to do so. The best solution would be to use reservation. Is something new, taking into account the present situation. And in my opinion, these reservations, they are best respects to sovereignty of member states. And I think that these reservations, they could serve the interest of the two countries. If the above change is not possible, I would suggest that the framework for regulating the acquisition of agricultural land should be regulated within the Treaty on the Functioning of the European Union, for example, within the framework of the Common Agricultural Policy. This is a de lege ferenda proposal. Such a regulation should be designated, in my opinion, to allow the positive integration model approach to be given priority in the land regulation of the member state that wish to apply it, as an exemption to the negative integration model. In this new regulatory environment, it would be important that member states were given the freedom to implement effective measures to ensure a long-term and reasonably transparent ownership structure in the agricultural land market, the long-term maintenance of traditional rural communities, and support for family farming and the improvement of the tenure of small-scale producers. In this context, the limitation on the acquisition of land by legal entities should be formulated as clearly termed applicable option. Member states should also be given the freedom to develop their own concept of rural community within this new system. I think it's extremely important. In other words, to be able to implement measures to support the survival of their traditional rural communities. And as to my second topic, it is the rules of agricultural irrigation. I hope that I did not violate the interest of my colleagues, that their achievements were presented only one slide, but after my presentation, you have the opportunity to detail your research, of course. However, as to the national regulation of agriculture irrigation, my delegate friend, the proposal connected to first, that development of territorial plans for irrigation and their implementation should further ensure that the concept of so-called landscape-based water management is applied. It demands, in my opinion, rethinking the way in which land is used in certain areas. And second, one of the key issues for agriculture irrigation is how to finance it, as these costs can have a direct impact on the price of the agriculture products produced, in addition to the sustainability of environmental service and thus on the competitiveness of agriculture sector and its producers. Agriculture that is unable to access water resources at reasonable prices will be left behind in the international competition. And that is the important referendum proposal from me. In our view, agricultural irrigation that correctly applies the concept of landscape scale water management can lay the foundation for the state to be more actively involved in the implementing landscape scale water management up to the extent of public interest, and for the boundary between the extent of public and private interest to be shifted towards the public interest. It means that, in my opinion, more public finance should be involved in the financing of these issues. And their colleagues, that was a kind of summary and presentation in a comprehensive way. Our group, their colleagues, thank you so much for this opportunity. And if I may, congratulations as to your achievements. Dear colleagues, now I have finished my presentation. And if I may, now I would like to provide the opportunity to Dr. Hornyak to deliver her presentation. After that, I would like to give the opportunity to Dr. Strala, and after that for Professor Adamus, and last but not least, definitely not least, to Dr. Chief. Dear Dr. Hornyak, the screen is yours.
Thank you very much. I try to share my PPT. Just a moment. I hope now you can see.
Definitely, you were
my presentation.
Yeah, you were successful.
Okay, thank you very much. So, dear colleagues, today I would like to speak about one topic, and this topic is from my research, but earlier I didn't speak about it. So it's not a De Lega Ferenda proposal of my whole research, but it's a new topic. It was the research topic of my scientific article. And I would like to highlight this legal position of young farmers, but in the concept of the land transfer situations. So first, I would like to speak about so the Hungarian land transfer regulation, and I would like to speak about the strict definition of a young farmer. And after that, I would like to speak the special rules for the land transfer of the young farmer. And first of all, I would like to speak about this young farmer definition and, of course, another category, which is the new agricultural producer, who is not a young farmer, but I think it's a very important category, and a little bit similar to the young farmer. But first of all, let's see the definition of a young farmer in the Hungarian land market. It means that a person who is a farmer, and I already spoke about the category of farmer in Hungary. It was the first open scientific seminar. So on that seminar, I spoke detailed about the farmer category and the condition of a farmer. So a person who is a young farmer has to be a farmer, and he or she has to be between the age of 16 and 40 years at the time of exercising the preemption right or the right of first refuse or for lease. So it means that this category is very important when we speak about the preemption right, and I will speak more detailed about it a little bit later today. And the other category is the new agricultural producer, who is not a farmer, but the main rule is that the rules of a farmer, so the farmer category and the rules of the farmer of the Land Transfer Act is applicable for this category. But it means only a domestic natural person or an EU national who is over the age of 16 years, and there are 4 conditions for this category. It means that the new agricultural producer has been habitually residing in Hungary under address registered as his residence at the time of making the legal statement for the acquisition of ownership of land. I already spoke about the statements also on the first Open Scientific Seminar in May. These statements are obligatory statements. It means that the person who will acquire the ownership of a land has to take these statements. One of the statements is that he will use the land himself, for example. But I already spoke about these statements. It means that the new agricultural producer will be an interesting and important question by the rules of these statements. And I will speak about it a little bit later. Another condition is that the new agricultural producer can be who does not own any land in any member state of the EU, in a member state that is party of the agreement on the European Economic Area, or in any other state enjoying similar treatment under international agreement. Other condition is that who has specific vocational skills or professional qualification in agricultural or forestry activities as provided for in the decree adopted for the implementation of the Land Transfer Act, and who is registered by the body in charge of agricultural and regional development aid as a new agricultural producer. And now I would like to highlight the categories, the special rules for this young farmer and for the new agricultural producer. It means that we have in our land transfer regulation some specific rules for these categories. Otherwise, the rules for the farmer we have to apply for this young farmer category. But it's a special rule, one of the special rules is that when we spoke about the preemption right or the first refusal right, when we speak about the land use transfer, in Hungary we have a very strict order in this regulation, and we have some if I can say, this order are in sections in our Land Transfer Act, and we have some subsections or subcategories or inner categories in this preemption right, in the order of the preemption right. And the young farmer and the new agricultural producer doesn't have any own main place in this order, but in some places of the preemption rights order are some inner preemption rights order, and here we can speak about the privileged position of the young farmer and the new agricultural producer. And in some places we can see that are some helping rule in the Land Transfer Act. It means that if in this place are more persons with the same preemption right, this order will be helping us to decide whose preemption right is privileged for the other. And it means this so-called inner preemption right in this order are on the second place the young farmer, and on the third place the new agricultural producer. This is one of the special rules for this for these categories. And we can speak about some other special rule, but not for the young farmer, just only the new agricultural producers. And the area, the topic where we can speak about the special rules are the statements, which I already mentioned today, because the young farmer and the new agricultural producers have to take the obligatory statements if he or she would like to acquire the ownership of the agricultural land. But if we speak about a new agricultural producer, he or she has to take some other statements as well. And here you can see that these plus statements he or she has to take when we speak about the acquisition of ownership of agricultural land, and also when we speak about the acquisition of use of the agricultural land. But the statements are the same. So the two plus statements are that he or she shall undertake to take up habitual residence within a period of 1 year from the date of acquisition at the registered address in the municipality where the land is located, or to set up a center of agricultural operations in the municipality where the land is located within 1 year from the date of the acquisition. And the other plus statement is that he or she shall undertake to engage in the pursuit of agricultural, forestry activity, or secondary activity. So it means that these plus two statements doesn't mean any relief for the new agricultural producers. We can say that these are some difficulties for the new agricultural producers. And I can say that there are only the special rules for the young farmer in the land transfer regulation in Hungary. And I would like to highlight, when we speak about the land transfer regulation, there are only the special rules for these categories. But if we speak about the holding transfer regulation in Hungary, there are a new legal institution, and I already spoke about this category, the transfer of agricultural holdings with a holding transfer contract. But the subject of this transfer regulation is the holding and not the agricultural land. And if we speak about the holding, we can see a so-called special young farmer category. So it's similar because we speak about really a younger person who is the farm transferee, who is under 50 years of age and at least 10 years younger than the transferor, and who can be a primary agricultural producer or an individual entrepreneur engaged in agricultural and forestry activities. And the farm transfer can be the person who meets the condition prescribed by law for the operation of the farm to be taken over, and must either be in the chain of relatives with the farm transferor or have been employed with the transferor for at least 7 years. These are the conditions for the farm transferee, who is the next generation, who is the so-called younger farmer category. But and in this regulation, I don't want to speak about detailed about this regulation because I already spoke about it. But I would like to highlight this regulation is really a relief for the farm transferee. It means that the whole process is easier for the transferee to acquire the ownership of the agricultural holding. And I think it is a good way, and it is a good institution for the generational change. And if we would like to speak about the EU level, I would like to highlight the young farmer definition and the regulation of the EU from 2021, when we speak about the Common Agricultural Policy Strategic Plans. It sets the minimum necessary common elements defining the criteria to qualify as a young farmer at EU level. And this definition includes the requirements for all relevant interventions under income support. This is the first so-called first pillar, and rural development as the second pillar. And this ensures consistency when EU countries address the objective of generational renewal in their CAP strategic plans. And firstly, a young farmer must be a farmer, and the EU countries must take into consideration the mandatory elements when drawing up their definition of young farmer. And these mandatory elements are the following. So a young farmer can be maximum 35 or 40 years old, and the EU countries are to set the exact upper age limit. A young farmer must be a head of the holding, so must have an effective control over the holding, and also the EU countries must detail the specifications, and the young farmer must have appropriate training on and/or skills, and of course the EU countries must detail the specifications. And when we speak about the support for young farmers in Hungary, I do not want to speak about the detailed regulation, but I would like to mention that the possibility to support young farmers appears in both the CAP pillars, the Pillar 1 and Pillar 2 in parallel, and the possibility of their simultaneous use is not excluded. And who can receive this support? So the applicant must at least 18 years old and not older than 40 years old, and the the time limit of the support can be maximum 5 years long, and the aid may be claimed by the young farmer or by one or more legal persons under the effective and long-term control of the young farmer, which must be done annually in the context of a single application. And the farmer applying for the basic payment for the first time must declare that he started his agricultural activity only a short time before submitting his application. And the last condition is a vocational qualification in agriculture or forestry. And the estimated amount of aid is 157 euro per hectare. And now I would like to mention two, I think, good practices in Hungary, because in Hungary is an association, the so-called AGRIA. It means the Young Farmers Association of Hungary, which was founded in 1996 and is a national agricultural and rural development organization. And currently they are in contact with more than 3,000 young farmers. And one of its main objectives is to represent the interest of young farmers. And as an interest representation organization, it participates in the professional decision-making processes and consultations. And another main objective of AGRIA is to help young people in rural areas who are not involved in agricultural production as well, to stay in their villages, and the young people who stay in the area strengthen the local community and take part and take responsibility in the life of the village. But the main aim is to help the young farmers by the association. And they have some tools. It means that the AGRIA have some priority programs. For example, the University Young Farmer Clubs, the Young Farmer Information Exchange, Young Farmer Conference, and also a Central European Rural Youth Center. And the other, I think, good practice in Hungary, that so-called Young Farmer Mentor Program. It means that if a young farmer applies to this program, he can get some help for his activity. There are 5 steps for this mentor program. It means some tender advice, some consultation with an expert advisor, an accounting advice, a legal advice, and a completed project plan and the financial plan. And every step of the process is supported by a mentor. And as a conclusion, I would like to mention the report of the European Parliament from 2017, and the point Z of this report, which says that whereas the future of the agricultural sector depends on the younger generation and on its willingness to innovate and invest, which is decisive for the future of rural areas, as it represents the only way to halt the aging of the farming population and to secure farm succession, without which the intergenerational contract also loses validity. Whereas, on the other hand, it is particularly difficult for young farmers and new entrepreneurs to gain access to land and to credit, which is liable to make the sector less attractive. And I think this is the main point and maybe the main problem when we speak about the Hungarian regulation as well, that we saw that in our land transfer regulation are only a few special rules for the young farmer, and these rules are not so. These rules do not make easier their tasks when they would like to acquire an agricultural land, acquire an ownership of agricultural land. So I think we have to reconsider our regulation in this territory, because now it's very difficult to acquire the agricultural land by a young farmer. There are only one way: if he is a close relative to the owner of the agricultural land. In this case, it's much more easier to get the land ownership, but otherwise it's very hard to get the ownership. And we have one more good legal institution, a new legal institution, which is the farm transfer contract. And I think it can be the future, and this way is a good way. And when we speak about the transfer of the agricultural holding, it is a good opportunity to the younger generation to acquire the ownership of the agricultural holding. And thank you very much for your kind attention.
Dear Dr. Hornyak, thank you so much for your presentation. And now I would like to give the opportunity for Dr. Strala to deliver his presentation. Dear Doctor, the screen is yours. Now we cannot hear you. No. However, I have seen the logo that you are not in a mute function, but somehow we cannot hear you. Nothing, unfortunately. Dear Strala, of course, later I'm going to provide you an opportunity, but before that, I would like to call. No, unfortunately, cannot hear you. Dear Dr. Strala, now I'm going to give the opportunity for Professor Adamus, and maybe you can find another way how to enter, maybe with your mobile phone or something similar. I do not know.
And maybe now?
Now it's perfect.
Okay, thank you very much. So sorry for this inconvenience.
No
however, may I continue, or maybe do you want
yes,
to?
You can. Sorry if I think it's okay.
Okay, thank you very much. So once again, I would like to start with thanks to you, dear professor, for giving me the opportunity to present my proposals and my analysis of the rules. I would like to ask whether you can see my presentation.
Yes, definitely we can see it.
And when I switch, it is seen also?
Yes, okay. It's okay.
Thank you very much. So, dear colleagues, dear professor, today another different topic from the previous ones I would like to deal with. It is called ritual slaughter of animals in Poland. It mainly deals with the conflict of the two values. One of the value which must be taken into consideration is the animal welfare and rights, so-called rights of the animals, and proposal of the reification of animals. And other very important value, in my opinion, is the right to manifest one's religion, right and freedom to act according to one's religions. Starting with some preliminary remarks. Some of the worldwide religions, especially, Islamic religion, Islamic tradition, and Jewish religions, require for their members, and some of the members can only eat such kind of meat, for the members to eat meat prepared with a very specific methods. This deals mainly with the cattle meat prepared without stunning. There are very precise rules, for example, in the Jewish religions, about who can do the slaughter, how it should be done with what of the tools it should be done, in what time, and so on. And as a part of this system of religious beliefs, it is important that to be ritually pure, you can eat only meat prepared in that way. So kosher meat, this is the word derived from the Jewish tradition, and the halal meat, this word derived in the Islam religion. And this necessity of eating this kind of meat is difficult according to the rules on the animal rights. If we consider the Polish constitution from the 1997, there is no explicit rules about the animal welfare or the animal rights. We can look through it to find implicit reference, for example, and as far as you can consider the right of the protection of natural environment, because the animals are part of the natural environment, and there is a rule in Article 5 of the Polish Constitution that the Polish authorities act according to the rule of protection of natural environment. However, this is disputable among the scientists and legal scholars, because some claim that this deals with the right of animals, and some claim that the natural environment means something different. The general provisions about the animal protection and their rights are included in the law from the 1st of August 1997, an abbreviation UOZ. Its title is the Law on the Protection of Animals, and in the very first lines of the text of this statute, you can find the rule that animal is a living being. It is capable of feeling, capable of suffering, and choose. Man owes it respect, protection, and care. So these rules, especially of respect and protection, is reflected in the precise, the particular provisions of this law, according, and must be interpreted in the light of this first general rule. As far as the EU rules on animal protection, there is a protocol number 33 on the protection of welfare of animals, also from the year 1997. Here you can find data about this promulgation. And this protocol, generally speaking, guarantees animal welfare. You can even find the rights to welfare of animals in the today also mentioned by the professor, Treaty on the Function of the European Union. It is Article 13. And you can see that the Union's politics, especially in the agricultural field, as well as the member states who implement the EU regulations, should pay full regard to the welfare requirements of animals. And the most important regulation in the field of the animal protection, because we have in the EU law a list of the regulations dealing with animals, for example, with animals during the cultural events and their welfare. In the field of the ritual slaughter, the most important is this one, regulation number 1099/2009 from the 24th of September 2009. And two things are important when we consider this regulation. The first one, this is the scope of the regulation. From the title, it may be derived that the scope is only protection at the time of killing. However, if we go through the motives of this regulation, it deals only in the field of business, killing for the commercial purposes in a slaughterhouses. Because this is the interest of the European Union, the common market, the agricultural politics, and not all the kind of the killing of animals, especially domestic killing of animals, is not within the scope of this regulation. And the main rule from this regulation is that the animals shall be spared any avoidable pain, any avoidable distress, and any avoidable suffering during their killing and relating with these killing operations. So the rule is that if any of the pain or suffering can be omitted, it should be omitted in the killing. And this is very important in the light of the rules for the animal slaughter, because it is done without the stun. This second value, which is in the conflict, is the value of the religious freedom. And differently from the animal welfare, religious freedom is more, you may say, from a longer period, is more anonymously agreed that there is such thing as a religious freedom. It is guaranteed not in some particular provisions, but in the most important agreements and declarations of the human rights. For example, it is guaranteed by the UN Universal Declaration of Human Rights, by the Declaration on the Elimination of All Forms of Intolerance from the 1981. As far as the Europe, it is also regulated in the European Convention for the Protection of Human Rights and Fundamental Freedoms. And it is also, as far as the EU is concerned, not the whole Europe, but the EU, European Union, is also available. It can be read in the Charter of the Fundamental Rights of the European Union. And of course, the Polish constitution reflects the international standards and also protects the rights to religious freedom. Not to go into details very much, it can be only stated that this religious freedom includes right to manifest one's religion, and it means right to act according to religion's beliefs of a person, of a physical person. The second regulation existing in the ECHR and the Polish Constitution, it is not in the Universal Declaration for Human Rights, for example, the limitation of this freedom. And the limitations had the enumerative lists of the prerequisites, conditions, or the values which can be only grounds for the limitation of the right to manifest one's religions, and are listed here. It is only the public safety, public order, public health, public morals, or the fundamental rights and freedoms of others. So if you go through this prerequisites, through these conditions, there are no such prerequisite as rights of animals or the animal welfare. There is no protection of of the natural environment as well. So if you want to limit it, for example, right to manifest religion, right to eat meat prepared with animal slaughter, you need to find a value from this catalog, and you need to have this proportion between the limitation and the value you want to protect, the animal welfare in this case. And how it was done within the European Union regulation, this waging these two values in the conflict. First, the directive from the 1993 declared in the motives that the EU regulations in the field of the slaughter of or killing of the animals should take into account the various religious rights with the special requirements of stunning during the killing of the animal. And in the case where the religion prohibits stunning to prepare the meat, the rules of stunning simply does not apply. So there was an exemption. The religious slaughter could be done according to this directive. Of course, the directive needed to be implemented in the internal law of the countries, and some countries can more or less precisely allow the ritual slaughter in the country regulation. Situation changes profoundly at the time of introducing the already called Regulation 1099 from 2009, because this is not the directive, this is the regulation which takes effect in the country internal system of laws at the time of the issuance in the European Union. So there is no implementation by the, for example, Parliament. And this regulation includes the general rule of stunning for the animal before the killing. In the Article 4, Paragraph 4, there is a exemption dealing with the special methods of killing of animals according to religious rites. And this exemption simply states that the rules of stunning does not apply when religious rites require animal to be conscious at the time of the killing. On the other hand, this regulation states that it provides only the minimal standards. So it is interpreted in the way that there is a exemption for the ritual slaughter from the rule of stunning. However, the country can forbid, can not make a regulation which will not allow ritual slaughter to be conducted according to internal laws. So this is the minimal standard, and the country needed to inform the Commission about the higher standard of the regulation when introduced in the internal system of laws. There are some dispute how it should be interpreted, whether this exemption can be wholly omitted and the country can prohibit all kinds of ritual slaughter. In fact, it can make the members of these religious communities unable to eat or buy meat prepared within the special methods of slaughter. Or on the other hand, others claim that this exemption is the minimal, and the countries can make some restrictions. For example, Germany introduced very special restrictions about ritual slaughter. It can be done, but by the person with qualified, registered, after issuing a special administrative decision for the ritual slaughter of an animal, but there is no way to prohibit it fully. And this is the different interpretation. What is interesting, this interpretation differ also in the opinions of the Attorney General of the EU from time to time. And how it is resolved in the Polish law. In the law from the 1997 on the right of animals, in Article 34, paragraph 1 and 3, there is simply prohibition for a slaughter without stunning. There are no exemption for the ritual slaughter. There was till 2002, but was abolished without much further explanation. And there was a case, one of the cases, but this is the most important one, the case brought to the Polish Constitutional Tribunal, which issued a verdict in the December of 2014, declaring that this provision, the text of the provision of Article 34, this rule that there must be a stunning every time when animal is killed in slaughterhouse or in domestic circumstances, it violates the Polish constitution, and it violates also the Article 9 of ECHR, which protects the freedom of religion. So this verdict allowed ritual slaughter. However, because it deals only with the paragraph 1, it formally allowed ritual slaughter only to be done in the slaughterhouse. This is a very interesting thing, because I believe there is no lawful grounds for differentiation between the domestic slaughter and the slaughter in the slaughterhouse. For example, how you may say that the religious rights are not important in the domestic slaughter, but in the slaughterhouse they are important. I believe this is not treated equally of these two situations. And what resulted from this verdict also? It resulted that the text of the statute, of the act from 1997, does not reflect the true state of the law. So when a farmer, for example, reads a journal of laws, he or she will read the text of the Article 34, paragraph 1, and maybe it is ambiguous whether this article still is enforced. It is not enforced, but due to the verdict of the Constitutional Tribunal, and not according to the text of the law itself. So it should be amended rather sooner than later. It should be amended, I believe, in 2015, but that wasn't done due to the unresolved debate, political debate in the Polish parliament, how it should be amended. And what is also important, the thesis from the written justification of this verdict of the Polish Constitutional Tribunal allowed not only members, physical persons or the religious communities, in German we say the Religionsgemeinde, to perform ritual slaughter for only internal purposes, internal needs of their members, but also it made it possible to conduct ritual slaughter in order to sell the meat prepared in that way. So, for example, it allowed slaughterhouses to prepare this meat and sell it on the market, and, for example, export it outside the Polish borders. What is important? The regulation from the 2009. There is an Article 26 which prohibits countries, member states, from prohibiting import of the meat prepared in the way that are prohibited in that country. What does that mean? For example, if Germany have very strict laws about the ritual slaughter, Article 26 of the EU regulation prohibit Germany from prohibition of import of the Polish meat prepared in the ways that are not allowed in the Germany. So this is kind of development on protecting the rules on the free transfer of the products, of the agricultural products. And what is important in this Article 26? I believe that from that rule about the prohibition of import, it can be argumented that the rules of the regulation from the 2009 cannot be interpreted in the way that it is possible to fully prohibit ritual slaughter. There was in Poland some opinions, especially when it was in the media, that the EU prohibited ritual slaughter in all European countries. I believe that this ordinance cannot be interpreted in that way, that it prohibits ritual slaughter in all of the EU countries. because of this Article 26, because it applies and it allows countries to export. So the opinions, for example, in one opinion of the Attorney General of the EU, that there can be full prohibition of the ritual slaughter in the EU, and it is in conformity with the EU regulations. It simply cannot be grounded by the argument that there can be exports from other EU countries, for example, to Germany, because when in all European Union there will be prohibition of the ritual slaughter, there will be no country for the members, for example, of the Jewish communities or the Islamic communities, to import meat, halal, kosher meat, and to buy it. So in some EU countries, there must be allowance of the ritual slaughter for the commercial purposes. So the main opinion in Poland that according to the EU rules, there is no way to ritual slaughter of animals in the slaughterhouse for the selling purposes is simply a misinterpretation of the EU regulations. On the other hand, another argument comes from the scope of the regulation from the 2009, as it deals only with the slaughterhouses and not the domestic slaughter. So to sum up and propose some de lege ferenda propositions, I believe that the text of the provisions of the article, especially Article 34 of the Polish Act on the Protection of Animals, should be immediately amended, and it should reflect the views of the Polish Constitutional Tribunal as it is created the new state of the law, and the text of the law should reflect the state of the law. And this amendment should precisely regulate the issue, of course, according to the views presented and adopted by the Constitutional Tribunal, because this precise regulation will protect the farmers from the risk of committing a crime. For example, there are very severe punishments for the slaughter of animals not in accordance with the regulations of this Polish Act, Polish statute. So we need to protect farmers and create the state in which there will be no uncertainty about the law and their interpretation. And the revised version of Article 24, I believe, by adding paragraph 7 to this article, should not only allow ritual slaughter in the slaughterhouses, but also a domestic slaughter. And finally, there is an issue, slaughter for the commercial purposes, because the member states can restrict the slaughter of animals or the religious slaughter only for the internal purposes of the religious communities. And I believe the EU regulations does not regulate this issue, because there is some margins of the freedom for the member states to regulate, for example, to allow the ritual slaughter for the sale purposes or prohibit it. It is a political decision. However, from the standpoint of from the view of, in the light of the protection of the farmers and their interests, it would be good to allow ritual slaughter for the sale purposes, and it will provide more protection for the rights of the members of the religious communities, and and the liberty of the religion, because it will allow more people and in other countries to manifest their own religion beliefs and able them to buy meat they need according to their beliefs. Thank you very much. I hope you're interested, and thank you for your kind attention once again. Thank you.
Dear Dr. Sala, thank you so much. I think these issues are important. And for example, also in Hungary, we dealt these aspects of animal slaughtery. And thank you so much for your precious contribution as the topic. And now I would like to invite Professor Adamus to deliver his presentation. Dear Professor, the screen is yours.
I am a very old farmer, so I need some of your help
Okay.
to present my
at the bottom of the screen, there is in the middle part, but the bottom, there is a red button.
Yes.
But first of all, it's good if you can open your PPT file as well, and maybe you also launch it. You started the PPT broadcasting, and after that, when you push this red button, you should select from different option. For example, the window option is in the middle on the panel, and when you click on the Windows option, you can select the proper one. Yes, that is.
Okay, is it visible or not?
It's perfect.
Thank you very much. Thank you for your help. I'm very grateful for your assistance with opening my presentation. Today, I'd like to ask a simple question. What is the future for insolvency law protecting farmers? I think that the financial system is based on the debt. So insolvency is a typical situation, is a typical case for anyone who is a participant in this market. And of course, farmers are also participants of the financial market, so they could be insolvent right now and of course in future. I think that it's possible to imagine what are the directions of the development of insolvency law, and I think that we should discuss possible changes in the philosophy of conducting of insolvency proceedings. I think that presented proposals, the referenda, are general. Farmers could be just one of many groups of market participants who get advantage of it. But I think that there are two major tools which are essential in the discussion of the future of insolvency law. I think that in future there will be a very wide use of artificial intelligence in order to help judges in dealing with bankruptcy cases and dealing with restructuring cases. And of course, it's also essential rebuilding the system of fundamental grounds called acceptance and negation rule. In short, acceptance and negation rule can be presented as follows. If there is no who objects the stage of insolvency proceeding, the insolvency proceeding should flexibly go on. And if there is any objection to the course of the proceedings, it should be the proceedings stopped and the judge should take the decision in order to decide which person has right and which person has no right to stop the proceedings, in order to be checked on of the judge who has power over the proceedings. I think that court intervention should be triggered after the debtor or creditor objection, and probably it is the future of the construction of the insolvency proceedings in nearby future. And I think that this model could allow for automatic opening of a proceeding based on the clear statement of the debtor that he is insolvent, submitted under the threat of criminal liability, providing false information. It's also possible organizing automatic determination of the debtor's obligations using artificial intelligence. It will speed up proceedings in a very good way. It's also possible automatic analysis of the ability to pay against the existing obligations. So artificial intelligence could check if the debtor has ability to make special payments for his creditors and in what installments, in what period of time. I think that it could be given to the artificial intelligence. It's also possible to create a plan for distribution of sums obtained from the liquidation of assets of the bankrupt. It's also possible to give the competence for creating so-called repayment plan in consumer bankruptcy. And of course, automatic cancellation of unpaid liabilities with so-called debt relief institution in consumer bankruptcy. It's also possible to do not by the effort of a human being, of the judge, but by the means of artificial intelligence. And I think it's a possible future for insolvency proceedings, protecting farmers as well. I prepared an example shape of a new simplified procedure using the potential of artificial intelligence. And I think that the proposed procedure, which will be very useful for farmers as well, could be divided into 3 stages. The so-called test stage is the first stage, explanatory stage, and executive stage, which is the last stage in order to perform the arrangement concluded between the farmer and his creditors. What are the characteristics of the test stage? I think that it's the starting point of the proceedings. And in this stage of the proceedings, any person, including farmers, could check in a preliminary way if he is capable to make a restructurization of his liabilities. And this is a very useful tool because there will be no information to anybody in the market that this test stage is exercised by the farmer. So it will be kept in secret as my proposal. I think that also essential proposal is that there will be no obligation to initiate any procedure if the recommendation of the test stage assumes we need to take further steps. So I think that the test stage could allow a farmer to check what is his situation, what he can do in future, what he can do in order to protect against his creditors, and he can do nothing after the test stage. It's open up to his decision what to do after the test stage. And of course, it's also important that some information about passing the test stage could not be used against the applicant. So it will be a kind of secret for a person who decides to use this test stage. I think that due to given data, due to capabilities of the system and artificial intelligence, the debtor could check what is his financial situation, whether he is at risk of insolvency, whether he is insolvent or whether there is no threat of insolvency. He could check what are the proposals for restructuring liabilities, what are the proposals for restructuring plans, and what are the proposals for restructuring assets by selling them to third parties. Okay. What about the data which is essential to make some evaluation of the situation of the farmer? I think that the farmer should give as small data as possible. I think that the status of overdue liabilities or liabilities not yet due, as well as future liabilities, if they are known, should be given to the system. It also should be given revenues of the farmer for the last 3 years. But in case of some farmers, it could be quite simple because it will be enough to, for example, give information of the area of sown area, the type of sowing, the date of harvest, and other data connected with agricultural production. And after such information are given, the system could give special remedies for the farmer after the data are given to this system. Okay. The test stage would not be mandatory but fully optional. This means that this test stage gives no privileges such as suspension of payments and immunity from enforcement. There are typical privileges in execution proceedings, but in the test stage they are not available. And the next stage is explanatory stage. It's the main stage of the proceedings. If the debtor submits the application at the next level with the time suggested in the test stage, then I think we could give a special fiction. The date of submission of the application would be counted from the date of initiation of the test proceedings. And another solution is the following. The system could decide on the completeness of the application and the grounds for opening it. So the opening of the proceedings will be automatic, and the judge could examine the legitimacy of opening proceedings only by virtue of objection lodged by the creditor within 7 days of the announcement of starting the proceedings. The judge could decide to suspend the effects of the opening of the proceedings, such as stop of the payment and immunity for enforcement proceedings. Okay. The effects of the opening of the proceedings are moratorium on performance of obligations and immunity from enforcement proceedings. After the expiry of time limits for possible challenge to the opening of proceedings or the dismissal of the objections lodged by the creditors, the system would present the debtor the optimal restructuring proposals, optimal arrangement proposals for creditors. But of course, it should be also a possibility for a debtor to give his proposals by himself. So it would be a choice in front of the debtor. He could, for example, base on the proposals made by the system or give his own proposals to the creditors. The next stage is connected with the activity of the creditors. It could be organized a traditional creditors meeting in order to vote over the arrangement between the debtor and the creditors. Of course, it could be remotely held creditors meeting, or of course, it will be possible to vote via internet or make votes in writing. Artificial intelligence could determine whether the arrangement has been adopted or not. I think that under this proposal, any creditor could challenge the conclusion of the arrangement within 14 days. In absence of objection from the creditors, the arrangement would be subject to automatic entry into force. And the final stage, the last stage of the proceedings, are executive stage. In the executive stage, the debtor should have a special settlement account with adequate funds for the implementation of the arrangement. The settlement account, the account of the debtor should be linked with the creditor's bank account, and the arrangement would be paid automatically, and the system would self-determine the final execution of the arrangement. And I think that it's all I would like to say today. Thank you for your attention. Sorry for my voice because I have a sore throat. Thank you very much.
Dear Professor Adamus, thank you so much for your presentation, and I hope the best as to your voice and of course as to your health.
Thank you.
And now I would like to call our colleague Dr. Czirski to give his presentation. Dear doctor, the screen is yours.
Thank you very much. Can you hear me?
I can hear you, however, I cannot see your
Yes,
presentation.
I think Professor Adamus should. Oh, okay.
Yeah.
Thank you.
Okay.
Now it's cool.
Thank you so much.
And can you see my presentation?
The situation is definitely better.
Oh, thank you. So, as to my last presentation concerning our open scientific seminars, I have chosen the topic which is which deals with the sustainability agreements in the agri-food sector. Maybe I could have initiated an earlier presentation for the topic, and I should have divided into 2 or 3 presentations, but now I only have one remaining chance to present these results and the research itself. So I will try to be concise and quick in that regard. So I have been doing research concerning the relationship between sustainability, agriculture, and competition. And the title of my article is Uneasy Complexity, which honestly describes the situation between these areas, and this uneasy complexity comes from several questions and from several directions, and the basic one, which is discussed among competition law scholars and enforcers, is the question whether competition law should contribute to sustainability at all, or competition law should remain in its area where only deals with consumer welfare, and in a strict sense it does not step out of the box of efficiency. There are diverse opinions in that regard. Another crucial contradiction between competition law and agriculture and agricultural law has been mentioned by me several times in my earlier presentations. As I mentioned, competition law and policy has a basic aim which aims to increase consumer welfare and the increase of economic efficiency, while agricultural law and policy has a totally different objective, which is helping agricultural producers, and as regards economic terms, I would say increasing producer welfare. And another open factor which shall be dealt with is the question whether which agricultural methods are sustainable at all. There are different opinions also in this regard. So as we can see, there are 3 distinct areas where many contradictions come to the fore, and basically, as I see, this is the question of this is the task of policymakers to decide whether they prefer one area to another, or vice versa. These are the summarizing thoughts. Sustainability and agriculture have a diverse relationships, and the private actors in the food supply chain must be cautious to treat their exemptions, their agreements as automatically sustainable. I I don't know why this slide came here, but yes, these were my hypotheses, and I think one moment, please. So maybe my slides have been mixed. So as I told you, sustainability and agriculture have a diverse relationship, but these are my final conclusions. So my research came from the fact that a new provision has been adopted in late 2022, and the Common Market Organization regulation has been complemented with an article which is numbered as Article 210A, and as you can see on my slide, it declares that Article 101 shall not apply to agreements, decisions, concerted practices of producers of agricultural products that relate to the production or trade in agricultural products, and that aim to apply a sustainability standard higher than mandated by union or national law, provided that those agreements, decisions, and concerted practices only impose restrictions of competition that are indispensable to the attainment of that standard. So Article 101 is the prohibition of anti-competitive agreements. So basically, this new adding in the Common Market Organization regulation creates a new exemption for agricultural producers, but I think quite confusingly, not only for agricultural producers, but also other market participants in the agri-food supply chain. So this provision has been adopted, and basically it came to a system of exemptions or system of derogations, because so far there was a two-pillar system concerning the exemptions under the prohibition of anti-competitive agreements. As you can see, the first one was Article 209 of the CMO regulation. The second one was Article 210 of the CMO regulation. The difference between these two first pillars was that Article 209 applies to horizontal agreements. So in the situation when competitors at the same level of the food supply chain attempt to agree on certain aspects of competition. For example, two agricultural producers agree on producing fruit or vegetable together. On the contrary, Article 210 applies to vertical agreements, basically to interbranch organizations. It means that the parties of these agreements are different actors from different levels of the food supply chain. So, for example, the parties of the agreement are producers as well as processors or even retailers. As a quite new solution, Article 210 has mixed these two approaches, and it applies to both horizontal and vertical agreements, and it is a specific provision in the regard that only sustainability agreements, so only those agreements can be exempted that have a sustainability aspect. Basically, I would say that the new derogation fits into the regime of the agricultural exemption system, but only concerning the voluntary assessment method, which means that for agreements to be exempted under the prohibition of anti-competitive agreements, there is no need for competition enforcement or for an official decision by the European Commission or by the National Competition Authority, but the parties of that agreement shall carefully assess whether their agreement can be exempted. Of course, if their voluntary assessment is mistaken or not correct, and the competition authority thinks or thinks that the agreement does not fulfill the criteria formulated by the new provisions and also by the older provisions, then it can initiate competition proceedings and it can examine the agreement whether it distorts competition in the relevant market. As I already mentioned, the personal scope of the new derogation steps out from the toolbox already used in the Common Market Organization regulation, since it does not require any legally recognized form of organization, which may open the door for more cases with arbitrary and unbounded legal interpretation. So while Article 209 basically, and the case law also suggests that officially recognized producer organizations can make use of the derogation, as well as concerning Article 210, only officially recognized and legally recognized interbranch organizations can make use of the regulation. Article 210A chooses a different path, and it does not require any legal recognition. Legal recognition comes from national authorities. For example, in Hungary, the Ministry of Agriculture has the task to accept a submission concerning legal recognition of an organization, and if it accepts, then it will be able to make use of these exemptions. I have not mentioned so far, but the draft guidelines have been issued by the European Commission concerning the new sustainability exemption in the agricultural sector, but I have identified some crucial point that is not so clever solution, I would say. But even the provision even the text of the provision suggests that sustainability agreements can be exempted also in the case if it has only one party who is agricultural producer. So it's quite mistaken, because it's not a too high requirement for a provision that has been adopted within the framework of the Common Agricultural Policy, which aims to increase the individual earnings of persons engaged in agriculture. So actually, if the agreement has one agricultural producer party and all the other parties are at a higher level of the food supply chain, for example, processors or retailers, they can also be exempted, and I think this does not serve the objective of the new provision to provide new possibilities for agricultural producers. And my approach is that it seems that with the means of aiming to help agricultural producers, other industrial and trading actors are provided with a helping hand, and unfortunately it is not the first time that the common agricultural policy with its legal basis has been used for the protection of market players who do not farm. It is enough to think of the UTP directive, which has its league, which whose personal scope also covers non-farming actors. So it is a quite interesting solution. And as you can see, the new provision uses the term operator, and it is not clear whether the hotel, restaurant, and catering sector is covered by the new provision. It is fully substantiated that the HoReCa sector is one of the most polluting sector concerning food waste, and in many aspects, and under the provision it is explicitly mentioned that sustainability can be connected to the reduction of food waste. However, it is not clear that for example, to stay with this example, the HoReCa sector can also use this exemption. I think they are part of the food supply chain, although they are at the end of the food supply chain, but with great initiatives, it would be easier, and it is quite easy for the HoReCa sector to reduce food waste. But of course, they should cooperate with other market actors, and it's not a clear part concerning the guidelines. As you have seen on my slide, the provision only applies when the sustainability standard that is agreed by the parties of that agreement is higher than mandated by union or national law. So, for example, a provision is adopted by national legislation or union legislation that creates a requirement for certain sustainable standards in an area, but the parties of the agreement who are so the parties of the agreement try to I would say overdo that agreement or that provision. So they try to provide a higher standard, and it of course means that it is not sufficient for undertakings aiming to make use of the exemption to agree on terms that should be respected anyways as a consequence of legally binding rules. There was an example, for example, in the Netherlands, that a certain kind of which comes from the fact that a certain kind of pesticide shall not be used in the territory of the European Union, and Dutch market players agreed not to purchase those agricultural products that were sprayed with that pesticide, and I think they do not fulfill the requirements of the derogation, because there is a national and not a national, there is a union and European Union legislation that prohibits the use of that pesticide, and the market players have only agreed that they won't purchase those products that were sprayed with that pesticide. So I think there is no higher sustainability standard than that should be respected anyways by legally binding rules. I think that this would raise the possibility of greenwashing, which means from the viewpoint of both consumer protection and antitrust law, which means that certain market players can advertise themselves as green and sustainable. However, their activity does not fully cover these statements. As you can see, a contrary standpoint came from the Dutch Competition Authority, which said that in a case when garden centers in the Netherlands have agreed to curtail the use of illegal pesticides by not marketing those plants that had been sprayed by these substances, can be exempted by the provision. By definition, as I have already mentioned, the reduction of food waste, sustainability standards can be related to a high number of phenomena, be it climate change mitigation, sustainable water use, food waste reduction, or reduced use of pesticides or animal welfare. I think this is as forward-looking as it is dangerous. My opinion, but maybe I am a little bit conservative in that regard. The question should be posed whether animal welfare actually contributes to sustainability. Of course, we can keep animals in a more humane way, and I'm not against it, but I don't think that higher cages for chicken would actually contribute to sustainability, and I have not found any real breakthrough to reveal the tangible positive effects of animal welfare on sustainability. And of course, it's I would say beautiful objective to raise the living standard of animals, and there were many examples also in the Netherlands, for example, where there was the so-called chicken of tomorrow, when they have tried to provide more livable and more and better conditions for chicken, and they agreed the prices of those chicken, and it's quite contradictory that this truly contributes to sustainability. And a further aspect that should be taken into account, that sustainable practices can conflict with other aspects of sustainability. For example, if intensively farmed animals were all kept extensively, there would be a large increase in demand for currently unfarmed land, and of course this could result in losses concerning biodiversity. Another crucial element of the exemption is the indispensability test. It means that the sustainability agreement must not impose restrictions which are not indispensable to the attainment of the efficiencies created by the agreement in question. And I think this test should be identical to the one carried out as regards Article 101.3 of the Treaty on the Functioning of European Union, which is the general and individual exemption under the prohibition of anti-competitive agreements. However, the draft guidelines stipulate that the guidelines on the application of Article 101.3 is only a useful starting point for the assessment of indispensability within the framework of sustainability agreements. But due to the certain key differences of the articles, it is different. There are differences between the two. My opinion is that there are no differences in the two cases. What is different is the objective to be achieved by a certain agreement. A higher level of sustainability may require a more tolerant approach towards restrictions. However, it does not mean that the essence of the indispensability test would change, as the factual circumstances to which we apply the test are the ones that are dissimilar, but we should do the same steps concerning the test itself. First, the indispensability of the agreement, and second, the indispensability of the competition restrictions. What the draft guidelines point out here, for example, the fair share of benefits to consumers is a distinct assessment criterion and should not play a role in the assessment of indispensability. And an agreement can be indispensable to achieve certain efficiencies, but may fall short of providing a fair share of benefits to consumer, and these should not be mixed as it is done in the guidelines. So the guidelines should not give the expression that there are different tests as regards different types of restrictive agreements. My conclusions are that this new exemption has been introduced in the agricultural sector, but it will not bring significant changes, since if a competition authority would have liked to assess an agreement, a sustainability agreement within the framework of individual exemption, it could do so. And the indispensability criterion is also part of the assessment of the individual exemption, and as I have mentioned, the two should not be different. And of course, there is an alleviation in the new provisions, since it does not require that a fair share of benefits coming from that agreement shall be returned to consumers. However, the new exemption is more strict in that regard, that it aims to that the agreement shall achieve a higher sustainability standard than mandated by law. So and further questions can be posed, like, for example, that in case the agreement does not meet the criterion of the new rules, new provision, can the general exemption which I mentioned in Pillar 1 and 2 can be applied to the particular case? My answer would be no. However, it is not in line with the draft guidelines, and it says that if the agreement does not meet the requirements of Article 210A, it can also meet the criteria provided for Article 209 in case of horizontal agreements, or 210 in case of vertical agreements. I think this new exemption should have brought more clearness in regards sustainability agreements, and it should signal that there are some limitations to have a sustainability related agreement exempted from the general prohibition. I think, however, that it will pave the way for the exemption of these agreements. However, its function would vanish by returning to the analysis in light of the derogations adopted earlier, and it may come with some greenwashing aspects that should not be permitted by authorities. So although there are many great innovations in the new exemption, and I think the basic objective to help agriculture-related sustainability agreements exempted under the prohibition of anti-competitive agreements, I think there are many shadowy points that should be examined carefully, and the case law is not developed yet, so it will wait for competition authorities to engage in more thorough analysis concerning these types of agreements. Thank you for your attention.
Dear Dr. Czirski, thank you so much for your contribution. And now, of course, I would like to provide an opportunity if you would like to ask each other, or if you would like to make some remarks. If not, in this case, first of all, I would like to draw your attention that please do not forget to send your article to me, the second written contribution as to the project. Of course, Professor Adamus, as far as if I can recall it correctly, he will have already sent it, and I forwarded it to the organizer. But I'm waiting for others' contribution.
I have also sent it to you.
Okay, please, in this case, would you be so kind to repeat it? And thank you so much. And please do not forget that in November, in the middle of November, we have a great opportunity to meet each other in a personal form in Warsaw. I'm absolutely look forward to seeing and meeting you in Warsaw. And thank you so much for your previous activity. Dear colleagues, I think that it's high time to close the opening seminar. In another form, however, I would like to continue this meeting with the Hungarian colleagues, taking into account that we have to arrange our transport into Poland in November. Dear colleagues, thank you so much and have a nice evening.
Bye.
Thank you very much, dear Professor. Have a nice evening too.
Thanks a lot.
Thank you, bye.
Akkor hívlak benneteket, Józsófi, meg Martin. Köszi. Sziasztok.
Okay.